Thank you. Yes, so thanks. Sorry about that. All this is just the introductory portion. So the visibility aspect of it, you have not missed a lot. And so we'll just pick up right here where I stop that the Office of Open Government also assists members of the public with filing FOIA requests with the appropriate public agencies. And these are the topics that we will cover today. DC's public records laws, records under DC FOIA, FOIA exemptions, requesting records, responding to FOIA requests, conducting searches for records and fees, and the final one, decision letters. And so the first, DC public records laws. DC's public records laws promote openness and transparency. And you have heard the public policy today, and if you attend Beggars Board meetings, this will be familiar to you as well. So for the benefit of those who did not attend the previous training, and also I would like to tie it in with the FOIA as well. So DC's public policy entitles all persons to full and complete information regarding the affairs of government and the official acts of those who represent them. And this is codified at DC Official Code Section 2-531, which also requires that the provisions of the FOIA be construed with a view toward expansion of public access and the minimization of costs and delays to persons requesting information. The statute was enacted in 1976 and was enabled by the District of Columbia Home Rule Act of 1973. The statute gives any person the right to request records in any form that are prepared, owned, used in the possession of, or retained by a public body. And when we look at scenarios, some examples of what constitutes public records, we'll see this description here, or the access coming into play more. When FOIA requests are submitted, agencies are required to make a reasonable search for the records. And on an annual basis, the district government agencies are required to report FOIA disclosure activities for the previous fiscal year to the Secretary of the District and the Council of the District. And so these are the sections of the OMA that are codified at DC Official Code, sections 2-531 to section 2-540, and you will see them being discussed in various scenarios as we move along. Managing DC FOIA. There's no central body within DC government that handles FOIA requests. Instead, each agency processes its own records, and the primary point of contact for DC FOIA is an agency's FOIA officer or an agency's director. And this is key. As we move along, we'll see the requirements, the importance of placing the FOIA officer's information on that agency's website. The DC Mayor's Office of Legal Counsel, MOLC, handles FOIA appeals. The DC Office of the Attorney General handles FOIA litigation through its Civil Litigation Division and provides FOIA advice through its Legal Counsel Division. The mayor of the district has also created the District of Columbia Open Government Advisory Group, known as OGAG. And OGAG advises the mayor on FOIA and other open government and transparency issues. The group includes subject matter experts from the government, and members of the public with expertise in open government. What's an agency's FOIA responsibility? Each agency head must designate an individual as its FOIA officer. And as you heard earlier, if you had joined in when Chief Counsel made that presentation, you would have heard that OOG's FOIA officer is Anthony Skirbo. Each agency must post on its website the name, title, address, telephone number, and email address of its designated FOIA officer. It's very important that the public, they readily know who they are supposed to contact as it relates to requesting records under FOIA. The FOIA officer's responsibility. Agency FOIA officers are responsible for tracking, managing, and responding to FOIA requests for records in their organization's possession and control, and administering their organization FOIA programs. Also, the agency's FOIA officer must conduct or coordinate a reasonable search for records and respond timely to FOIA requests. And as we move along, and we've heard earlier about the crucial element of responding on time, because when a FOIA request is not responded to on time and there has not been an extension taken properly, then that will constitute a denial. And so our next topic, records under DC FOIA. And DC FOIA mandates proactive disclosure of certain documents. So these records must be made available to the public without the need for a FOIA request. It includes employees' name, that's government employees' name, salary, title, and employment dates, contracts, expenditures, budgets, manuals, policies, rules, opinions, orders, and meeting minutes of public bodies' open proceedings. And this last one here, it's related to the Open Meetings Act. And so we see that statute coming into play as it relates to FOIA. What is considered public record under FOIA? The term public record is defined DC Official Code Section 2-502-18. And this is the definition. It includes books, papers, maps, photographs, cards, tapes, recordings, vote data, or other documentary materials, regardless of the physical form or characteristics, prepared, owned, used, in the possession of, or retained by a public body. And if this sounds familiar, when we just started, we looked at who can request records. And so we see an overlap, what records can be requested. And public records, it also includes information stored in electronic format. And electronic format now includes text messages and some applications. And there's an advisory opinion that we will look at later that Director Allen issued in 2022. Public records include certain private contractors' records. And so these public records include any records produced or collected pursuant to a contract with a private contractor to perform a public function. And so the mere fact that the contract is is outside, then it's a contract, it's outside of the government, that in and of itself does not operate to exclude those documents related to the contract or the contract from FOIA. And we have fun sections here. We're going to test our knowledge, public records, our question and answer segment. And this is our scenario and our question. At the direction of an agency's director, the IT manager migrated the agency's records to the director's personal server at home. Are these records agency records? Okay, so we have our three selections here. I will just close this window. There we go. And so A, they are not maintained by the government and are therefore not public records. B, they remain agency records subject to FOIA. C, the records are no longer public records because they are stored on a private server. And so while I'm not able to see the chat, I will give you a second there to get your answers in. And the correct response is B, they remain public records subject to FOIA. Change in location of a public record in and of itself does not change the public record's character. Remember our definition we looked at there earlier. Another scenario followed by a question. Sarah's co-worker Jim is on vacation overseas and she wants his guidance on a document that must be submitted to another government agency within an hour. Sarah knows that Jim has left his government-issued cell phone at home, but will readily respond to text messages via personal cell phone. Sarah sought and received Jim's input for the document by text on his personal phone. Now, are the text messages public records? Go back to that definition, and I'll give you a few seconds there to get your responses in, even though I'm able to see a few now. I'm seeing some yeses there. So let us see. Let's choose. So A, no, the text messages are not agency records because Jim used his personal cell phone. B, since it was imperative that Sarah got Jim's input to submit the document timely, the director of the agency must decide whether to classify the text messages as public records. C, the text messages are public records as defined by statute. And let us see. The correct response is C. And so I know I've seen, yes, I've seen C there. I've seen some yeses even before I got to the ABC aspect of it. So the text messages are public records as defined by DC Official Code Section 2-502-18. And this is the advisory opinion I spoke about earlier that Director Allen issued in 2022. Director Allen opined that district government employee who conducts government business via text or similar electronic method within the scope of the individual's employment creates a public record under DC FOIA. And I was rereading, I read that opinion again yesterday, and I would invite you to go ahead and read it. It's a lengthy opinion. It has so much information as it relates to text messages in various forms, because we know technology has increased, has advanced so much. And so the link is here. I've provided it for easy access to reading that advisory opinion. Moving along here, this is a recap of the term public record, that it applies where the content is prepared or used by a public body and the means of storage is immaterial. Government personnel cannot evade DC FOIA by preparing records on media which they own. And so if a government employee decides that he or she wants to send a message, but it's a message that they will not want to be accessible via a FOIA request, and decides to use a personal phone or personal computer, that's a way of trying to evade the FOIA, and that is not allowed, it's not permitted under the statute. It is if it's that employee is working within the capacity of that as an employee carrying out the functions that they ought to carry out, that record is a record of that agency, notwithstanding that a personal phone or a personal computer has been used. And so we have a case here on point. It is Competitive Enterprise Institute against Office of Science and Technology Policy, where the Court of Appeal held that if the agency head controls what would otherwise be an agency record, then it is still an agency record and must be searched or produced. The Court of Appeal also states that an agency cannot shield its records from search or disclosure under FOIA by the expedient of storing them in a private email account controlled by the agency. And the court also tapped into what the Supreme Court had to say earlier as it relates to FOIA to bolster that opinion, and that FOIA serves the citizens' right to be informed about what their government is up to. And so there must be openness and transparency. Moving along here. And now we're at our exemptions. So we know that if we are reviewing records, it's been reviewed in accordance with FOIA. And so the exemptions invariably they come into play. The only way that you will not be applying exemptions if you're not looking at the documents and reviewing with exemptions in mind is after reviewing, you have determined that the record is non-responsive. But as long as that record is responsive, you are keeping in mind the exemptions of the statute. And so let us move along here. The exemptions are DC Official Code Section 2-534. And so what does exempt means? It means that certain records or information held by government agencies are not required to be disclosed to the public, even in the face of an appropriate or complete FOIA request. So exemption 1, which is trade secrets. And this exemption, the agency must show, 1, that a trade secret and or financial information is there. 2, it was obtained from outside the government. And 3, it would result in substantial harm to the competitive position of the person from whom the information was obtained. And DC Circuit has defined trade secret for the purposes of federal FOIA as a secret, commercially valuable plan, formula, process, or device that is used for the making, preparing, compounding, or processing of trade commodities. And that can be said to be the end product of either innovation or substantial effort. The DC Circuit has also instructed that the terms commercial and financial used in federal FOIA should be accorded their ordinary meaning. And a well-known Supreme Court case, Food Marketing Institute against Argos, the Supreme Court held that information is confidential and protected if the information is customarily kept private or at least closely held, and where the receiving party provides some assurance that the information will remain secret. And so if that individual submits the document to the government agency and has not indicated in any way, any form, that the information must be kept secret, then we have an issue there in terms of applying the seeking to apply the FOIA exemption 1 to that record. Moving along here, exemption 2, personal privacy. And this exemption has another prong to it, which is 2A, body-worn camera. So information of a personal nature where the public disclosure of the information would constitute a clearly unwarranted invasion of personal privacy. And at first blush, when many look at the federal equivalent, which is Exemption 6, it appears as though DC FOIA is broader. It's more encompassing. However, the Supreme Court has found that where personnel and medical files are stated under Exemption 6 of federal FOIA, similar files has been added by the Supreme Court, and so it comes on equal footing with DC FOIA in terms of the records that are covered, are considered personal privacy under this exemption. And so the next prong of personal privacy, 2A, any body-worn camera recordings recorded by the Metropolitan Police Department, A, inside a personal residence, or B, related to an incident involving domestic violence, stalking, or sexual assault as defined in these codes. And personal privacy, there's much to say on it, but I will be brief. I'm mindful of time here. But DC FOIA exempts personal information of public employees unless the requester shows that the withheld information will shed light on an agency's performance of its statutory duties or otherwise let citizens know what the government is up to. And so it's a matter of transparency of the government. And also that includes a government employee operating in the capacity of that employee. So when it comes to personal information that doesn't have anything to do with the operation or functioning in that capacity, then this is what the DC Court of Appeal has addressed, and that information is not covered. And so as it relates to personal privacy, I'd like to also point out that the threshold laid down by cases, and it's applied by DC and on the federal side, is if there is more than a de minimis privacy interest, then it is that the balancing test will come into play. And what is this balancing test? When determining whether the exemption for personal privacy would apply to requested records, it's set forth in the Department of Justice against Reporters Committee for Freedom of Press, which requires that the government balance the individual's privacy interests against the public interest in disclosure. And so a FOIA officer must perform the balancing test under this exemption. The individual's privacy interest in the material at issue must be balanced against the public interest in disclosing it. And this public interest must serve the core purpose of shedding light on an agency's performance of its statutory duties. And there we go again, transparency and openness of the government. And so let us move along here with our exemptions. Law enforcement, exemption 3. And this covers investigatory records compiled for law enforcement purposes, including the records of counsel investigations and investigations conducted by the Office of Police Complaints, but only to the extent that the production of such records would, 1, interfere with enforcement proceedings, counsel investigations, or Office of Police Complaints ongoing investigations. Sorry about that. Or deprive a person of a right to a fair trial or an impartial adjudication, constitute an unwarranted invasion of personal privacy, disclose the identity of a confidential source, Another one, disclose investigative techniques and procedures not generally known outside the government or endanger the life or physical safety of law enforcement personnel. And there's a bit also I'd like to add for each exemption. I want us to get the salient points associated with them. So while the threshold requirement for this exemption to apply is that the record or information sought must have been compiled for a law enforcement purpose, the courts have held that the law enforcement purpose encompasses a wide variety of records and information. So records compiled as part of violence investigations or drug trafficking investigations, including records pertaining to the use of informants, have been found to meet the threshold. Also, records compiled as part of investigations into non-violent illegal activity have been found to satisfy the threshold, as have records used in efforts to prevent wrongful activity. And so while the courts grant agencies wide latitude in defining their law enforcement purposes, the courts have denied protection under this exemption when the agency did not demonstrate, one, that the records were compiled as part of the agency's stated law enforcement purposes. And so we're now looking to what the agency has as their law enforcement purposes, what is stated, and not just looking at a FOIA. Two, the records existed independently of the stated law enforcement purpose. And three, the associated investigation was conducted for an improper purpose. So let us move along to our fun exemptions. All of them are fun, but this one has various prongs, and I like to work with exemption 4, whether under DC FOIA or federal FOIA. And so this covers agency communication, interagency and intra-agency memorandums or letters, including memorandums or letters generated or received by the staff or members of the council, which would not be available by law to a party other than a public body in litigation with the public body. And so interagency, two agencies, communications, intra-agency, an example here at BEGA, OOG's sister office, OGE, and that would be an intra-agency communication. So let us go ahead and look at the different prongs here of exemption 4. And so exemption 4 incorporates civil litigation privileges, deliberative process, attorney-client, attorney-work product. And this is specifically incorporated, is stated DC Official Code Section 2-534, subsection E. And we have more to this exemption, looking at what is deliberative. So there are two elements of deliberative process privilege. They are pre-decisional and deliberative, of course. And so we want to look more at what is pre-decisional. So pre-decisional communications precede the adoption of an agency's policy. For the pre-decisional element to be found, the agency must be able to identify a decision-making process that led to the creation of the withheld documents. A document is deliberative if it is part of the agency's give and take process by which the decision itself is made. And a note here that on the federal side, courts have recognized documents to be pre-decisional, even though they have not arrived at a decision, a particular decision. But there is a process. There was a process. It's just that there is not a final decision. So that's something to take into consideration under exemption 4. And we do have another prong to exemption 4. I told it was exciting. And so it's third-party communications and the deliberative process privilege. So it doesn't generally apply to communications that include third parties. However, there is the consultant corollary. And this is where a third party has independent interest. It doesn't have an interest then in the stake of what is going on. It is aligned, the interest is aligned with the, I'm sorry about that, the third party's interest is aligned with the government's interest. And so that's key for consultant corollary. I guess I'm getting too excited about exemption 4. Let us look at it in light of some cases. And so we have two cases here. One is where it was paid employment, and one where it was unpaid, it was volunteer. And so that in and of itself, being a volunteer, we'll see that that does not remove the consultant corollary aspect of it. And so the case where there was a paid relationship or employment is Hoover against the Department of Interior. And both cases were decided by the Fifth Circuit. And so Wu against National Endowment for Humanities, that was the volunteer, a scholar of Chinese history who had previously filed an application for a grant from the National Endowment for Humanities to write a history of the Chinese people, sought disclosure of the reports of the 5 outside experts who had evaluated his personal and recommended his proposal and recommended that it be rejected. The court denied the disclosure request, holding in part that the experts' reports were intra-agency memoranda, even though the five professors were not actually agency employees. I told you that I get excited about exemption 4. I'll calm down. And so we see a key element here, and it is that the evaluators, the experts, the 5 experts, they do not have a personal interest. There's no personal interest. Their interest is aligned with that of the government. And so being unpaid volunteers, that did not hinder the application of the consultant corollary doctrine. And so who is a consultant? This well-known case, Department of Interior against Klamath water users, it has given us a clear guideline here of who's a consultant. So the Department of Interior had consulted local Native American tribes on assignment of water rights. And significantly, the tribes were among many applicants for the water rights. The Supreme Court ruled that the tribes could not be considered consultants to the Department of the Interior. Why? The court explained that an outsider cannot be a consultant when the outsider is seeking a government benefit at the expense of another party. And so they had an interest there, a personal interest. Their interest was not aligned solely with the interests of the government. And so we will skip through these exemptions. They're here. You will have, and they're of course in the statute. You can go ahead and look at them and as it relates to your review of your documents. But what I'd like to do is to jump from exemption 4 to 22 and 23. Reason being, they have been recently added. The FOIA has been amended to add these two sections here by the Freedom of Information Clarification Emergency Amendment Act of 2025. And it relates to the Criminal Justice Coordinating Council and the District of Columbia Sentencing Commission. And both information is the same for them, information or data provided by any court, federal agency, or federally established agency, and to the CJCC and the Sentencing Commission. So let us move along here. And this is some more information as it relates to the amendment to FOIA. Our next topic, requesting records. So who may request records under FOIA? Any person has a right to inspect at his or her discretion to copy any public record of a public body except as otherwise expressly provided by the FOIA exemptions. How to submit a FOIA request. Request for an agency's records, it may be made orally or in writing. And if it's made orally, the agency may require that the requester submits the request in writing. And these requests, FOIA requests, they may be mailed, faxed, or emailed. And the applicable regulations is in 1 DCMR section 400 8sec, and the link here to the regulations, it has been provided, the website. So this is key. A FOIA request must be specific. The request must reasonably describe the desired records and, if possible, specific information regarding names, places, events, subjects, dates, and the list goes on. The reason the FOIA officer or those in the helping to process the FOIA request do not want to address an overbroad request or try to get into the mind of the FOIA request. I see something pop. Can you hear me now? Sorry about that, all technology. I am not sure what happened there. I know I got a bit excited, but I promise I didn't click, I didn't touch anything. So let us get back here on track. So we were talking about FOIA requests must be specific, and I will repeat, I know time is going, but I'll repeat the slide for those who could not hear. I was explaining the reason for a FOIA request to be specific, because if it is not, and the FOIA officer tries to get into the mind of the requester and possibly process the FOIA request, a FOIA request that doesn't entail what the requester had in mind, it's imperative that the FOIA officer seeks clarification. And so what can be requested under DC FOIA? Email messages, text messages, notes, databases, files, other communications, camera footage, video footage, photographs. And we're at one of our fun segments here again, and it's the question and answer. Let us test our knowledge on requesting records. Which of the following is correct? A, any person only includes any United States resident. B, any person describes a person natural or corporate with residence or location anywhere. C, any person includes only natural persons with residence anywhere. Now, just give you a second there to get your response. And I'm able to see, I'm seeing some A's, I'm seeing B, I'm seeing B. So let us go ahead and see here. The correct response is B. It's similar to a federal FOIA, where any person includes non-resident and corporate entities. And so under DC FOIA, the mayor, the council, or an agency is not permitted to make a FOIA request. And this is similar to federal FOIA in that a federal agency does not have the right to file a FOIA with another federal agency requesting record, but state and local governments are permitted. They have the right to do so. And let us go ahead and look at our neighbors, Virginia. Whereas Maryland, DC, and federal FOIA allow any natural or corporate person with residence or location anywhere to request records under their respective FOIA, Virginia only allows residents to request records under their FOIA. So we have another question here, test our knowledge. Do requesters have the right to make anonymous requests under DC FOIA? A, yes, a requester may submit FOIA requests anonymously if the records being sought do not pertain to the requester. B, no, a requester is not permitted to submit requests for records anonymously under DC FOIA. C, a requester is only permitted under DC FOIA to submit a FOIA request anonymously for natural persons, but not corporate persons. Okay, let's see. I see B, I see A, C. Wow, we are just doing the alphabet here. Okay, so let us see what we have. The correct response is A. And 1 DCMR Section 402.3 states a request shall include a daytime telephone number, email address, or mailing address for the requester. So we see absent here is the identity of the requester. So a FOIA requester is permitted to make a FOIA request anonymously. And we have another. So if you lost out on the previous, you have a chance here to make up. So Squeaky Clean Corporation was awarded a contract by a DC government agency to provide cleaning services at certain public parks and the streets surrounding the parks for 10 years. Are the records pertaining to the contract any public record and as such subject to DC FOIA? Let us see if I see a no there. I see a no. Okay, I see a yes. So let us move along and check. A, yes, Squeaky Clean Corp must consent to the requester's access to the records. B, no, the records are not covered by DC FOIA. C, yes, the records are subject to the FOIA because they were produced or collected under a contract between the government and a private contractor to provide a public function. So let us see. The correct response is C. So we have our relevant statute here. The key is public function. Remember, we spoke about that. A public body shall make available for inspection and copying any record produced or collected pursuant to a contract with a private contractor to perform a public function. And the public body with programmatic responsibility for the contractor shall be responsible for making such records available to the same extent as if the record were maintained by the public body. And our next topic here, responding to FOIA requests. Responding to FOIA requests. The steps. When an agency's FOIA officer receives a FOIA request, the FOIA officer must acknowledge receipt of the request via email message or other initial communication to the FOIA requester. Key. DC has an automated system provided through GovQA that the public may use to make FOIA requests, and DC agencies may use to process FOIA requests. And so the GovQA, it automates this DC FOIA process. And the FOIA officer must assign the FOIA request an internal tracking number or use some internal tracking system to keep track of the FOIA request, to be able to communicate correctly with the FOIA requester. And if there is an appeal or for whatever other use, it is essential for that FOIA to have a tracking number. Moving along here, continuing on with responding to FOIA requests. And so an initial response, that's the acknowledgement letter, and it must have an introduction and an acknowledgement acknowledging the receipt of the FOIA request, any clarifying questions if needed, a discussion of fees if warranted, and the processing track designation if you're able to determine at that juncture. And also contact information for questions, complimentary close, for example, sincerely, written signature, and a type name and agency, your title. So the FOIA requester will know who to get in touch with, to follow up with about his or her FOIA request. So timing for final responses. And key here, acknowledgement letter is not a final response. And so Chief Counsel spoke about the time limit. And so for records, I'm just going over it here a bit in the context of my presentation. For records other than body-worn camera recordings, the agency must reply within 15 business days. And so this excludes Sundays, Saturdays, weekends, and public holidays. And for body-worn camera recordings, it's 25 business days. And then we will look at extension, which I know that Chief Counsel Neal touched on as well. And so the statute affords extension of 10 days for records other than body-worn camera recording, and 15 days for body-worn camera recording. And it's essential. Both parties must be of the same mind. So communication is key here as it relates to the extension. The FOIA officer must communicate in writing to the requester that the extension is applied, and the reason for the extension as well. And so these extensions, they are permitted under the statute because of what is called unusual circumstances. And unusual circumstances are the need to search for, collect, and appropriately examine voluminous amount of separate and distinct records that are demanded in a single request. Also, the need for consultation, which shall be conducted with all practicable speed with another public body having a substantial interest in the determination of the request, or among two or more components of a public body having substantial subject matter interest in the document. And so we see practicable speed here. So even though the extension is permitted because of the need for consultation, the FOIA officer must also be mindful of doing such with all expediency as much as possible. And so the unusual circumstance as it relates to camera recordings is the inability to procure a vendor that is able to perform the redactions within the 25-day time period provided under the statute. And we covered in part how to take that extension, that it must be communicated in writing. And so if you're using the automated system, that feature is included. And earlier we spoke about the consequence of not, or one of the consequences of not responding on time. The result is that it will be deemed a denial if that extension has not been communicated properly as required under the statute. And so I'm watching our time here. Let me try to move along quickly. Our next topic, conducting searches for records and fees. All hands on deck. So all with access, who maintain the records, must pitch in, must be involved, must help, assist in whatever way to get those documents ready for review. So all agency employees who maintain records must assist the designated FOIA officer as appropriate with the identification of and search for responsive records. And so, yes, this is, you have your FOIA request. Now, where do I start? So each agency should have a records officer or a person who is designated or responsible for an agency's records. And that employee should assist you with locating the records requested. So examine your agency's organizational chart, as it may provide details as to who may possess a particular record. And if the request is for email or other electronic record that the Office of the Chief Technology Officer, OCTO, maintains, you may have to request it through your general counsel. Also, examine the agency's records retention schedule to make sure the record requested has not been archived, because there's a difference when the record is archived from when the record is at the record center. So when it's at the record center, it's still in the custody of the agency and in the holding of the record center. And so that FOIA request must be processed by the agency. So what is the FOIA officer required to do? A FOIA officer must conduct an adequate search for records responsive to the request. And in assessing whether a district agency conducting an adequate search in response to a FOIA request, courts look not to the fruits of the search, but to the appropriateness of the methods used to carry out the search. We have a case here on point with a citation, Comptroller of Currency. The issue to be resolved is not whether there might exist any other documents possibly responsive to the request, but whether the search for those documents was adequate. How to conduct an adequate search continues. An agency search conducted in response to a FOIA request, it need not be perfect, only adequate. And adequacy is measured by the reasonableness of the efforts in light of the specific request. And so each request is taken on its own accord on what it states, what it's requesting. The search must be reasonably calculated to uncover all relevant documents. And we have our cases here on point. I'm just moving along so that if there are any questions. FOIA fees. So there is no fee for submitting a FOIA request, but there are fees for conducting searches, reviewing, as the case may be. The statute speaks to the difference between commercial type requests as opposed to media or educational type requests. And so agencies may charge fees for conducting record searches. And another thing is that agencies may grant public interest waiver fees. And those who are processing, the FOIA officer and those who are processing the FOIA request, they must keep a log of the time spent. And so we'll see the reason why, because the fees charged are tied to the pay grade of the personnel, the person who performs that search or review. And another key thing is that even when the records are not released, when they are withheld in full, fees may be charged for search and for review as well. So that's a key thing there to bear in mind. And I'm just moving along in the interest of time. And if anyone has any verbal questions at the end, decision letters. What's required in an agency's decision letter? It should contain these information. One, whether the record was released in full, partially released, that is redacted or withheld in full. Two, the name and contact information of the person who made the decision concerning the release of records. Three, reference to the DC code provision, that is the basis of the decision, and a statement advising the requester of appeal rights. And so we'll see three. We have an extension to 3 here. And it's the don'ts of decision letter. Do not use the language if construed as a denial when you are very clearly denying the request. It is confusing. Make sure your boilerplate is accurate. Also, do not withhold multiple records using multiple exemptions with a single omnibus sentence. So if you have 3 different documents, a contract, memoranda, letter, there are different exemptions that apply for each record. You're going to name the record, state the exemption that applies, and the reason why that exemption applies. And this is laid down in the regulation as well. Let us move along here. And we're pretty much at the end. So this is a summary of the FOIA process. Step one, you receive the FOIA request. Step 2, you process the FOIA request, which entails logging the request internally, creating a case file, estimating the fees, sending acknowledgement letters. And step 3, retrieve records. And this entails search for responsive records, request records, review records. And step 4, process the records. So you make your redactions, you apply your exemptions, you calculate your fees. And step 5, you approve the release of the records or deny, as the case may be. You draft your response letter that includes the fees, or if you're granting a fee waiver, and you release the records if you're releasing, and also if you are invoking that portion of the rule for the requester to pay before release of records because there is outstanding fee or there are outstanding fees. And also FOIA, DC FOIA states that if the amount is above $250, the agency or the FOIA officer has the right to also request a payment before release of the records. And so I believe, yes, we are at the end here. And I'm just 2 minutes over. Apologize for that. So this is our contact information, the Office of Open Government. If you have any questions after today, we're here ready to answer your FOIA questions. The email address is there and the members of staff. And so thank you for joining us for this training. And I apologize again for those technical issues that we have experienced. There is an upcoming training at 3 p.m. on parliamentary procedure. Will be presented by Susan Leahy, founder of Robert's Rules Made Simple. And also Ethics Week continues when on tomorrow and Friday, our sister Office of Government Ethics will continue with exciting and informative presentations. So I'm just checking to see if there's any unanswered questions. Are we sharing the slides? Yes, the slides, they will be available on open-dc.gov. That's on OOG's website. If I miss, colleagues, if I miss any questions, please let me know before I close out here. I'm checking. You are all most welcome. I don't see any here. So I thank you all again and have a great rest of your afternoon.